Hello friends, my name is Nizamuddin Ahmed Siddiqui and I am an assistant professor of law at the West Bengal National University of Juridical Sciences, Kolkata. I will be taking this unit on the justiciability of fundamental duties. On behalf of the content writer, Dr. K. Sita Manikayam, assistant professor, Dr. B.R. Ambedkar Law College, Andhra University. This unit aims to fulfill certain learning objectives, which include: number 1, learning about the concept of fundamental duties and their achievements. Number 2, an understanding about the legal provisions for the enforcement of these duties in the Indian Constitution. Number 3, an appreciation of the enforcement of fundamental duties with the help of judicial pronouncements. Rights and duties are inseparable. They are two sides of the same coin. As we have fundamental rights which we enjoy, there are also fundamental duties that we must follow. These two terms, fundamental rights and duties, are therefore correlated, and either of them cannot be ignored. The fundamental duties of Indian citizens contained in Part 4A were added by Articles 51A by the 42nd Amendment 1976 on the recommendation of the Swaran Singh Committee. These duties set in Part 4A of the Constitution concern individuals and the nation. Let us look at the recommendations of the Swaran Singh Committee. The Swaran Singh Committee, selected by the government for an assessment of the Constitution, and it was entrusted with the task of formulating some proposals for inclusion in the Constitution with respect to certain fundamental duties and obligations. These duties and obligations which every citizen owes to the nation, inter alia, to sustain and strengthen the integrity and unity of the nation, to act in accordance with the Constitution and laws of the land, to maintain discipline in every sphere, to honestly perform all duties, to safeguard property. After a detailed discussion, the Swaran Singh Committee recommended inclusion of the following 8 fundamental duties into the Constitution. Number 1, the duty to uphold the sovereignty of India and function in the way to strengthen the unity and integrity of India. The duty to respect and abide by the Indian Constitution and the laws of the nation. Number 3, the duty to respect every democratic institution enshrined in the Constitution and to avoid doing anything that may impair their dignity and authority. Number 4, the duty to abjure communalism in any form or manner. Number 5, the duty to defend India and to render national services whenever required to do so. Number 6, the duty to assist and cooperate in implementing the directive principles of state policy and promoting the common good of the nation in order to subserve the interests of economic and social justice. Number 7, the duty to pay taxes as is required by laws of the land. And number 8, the duty to safeguard and protect public properties and not doing anything that may either cause destruction or damage to such properties, besides abjuring violence. Friends, the duties proposed by the committee were to be obligatory in nature. The committee therefore suggested that the Parliament may, by law, provide for an imposition of such penalty or punishment as may be considered appropriate for any non-compliance with or refusal to observe any of these duties. The panel went on to recommend that no law imposing such penalty or punishment shall be called in question in any court on the ground of infringement of any other provision of the Constitution. The committee was of the opinion that the abuse or misuse of the rights conferred under Article 19 may be by any individual, a group, a party, or an association, and each of these would have to be guarded against. The 42nd Amendment did incorporate some of those duties, but in a modified form. Moreover, the duties were not made enforceable in a court of law. According to the statement of objects and reasons appended to the bill, the 42nd Amendment was intended to achieve the objective of socio-economic revolution, which ends poverty and ignorance and disease and inequality of opportunity. Finally, in 1976, the fundamental duties were incorporated in the Constitution by the 44th Amendment Bill, which was later adopted as the 42nd Amendment Act of 1976. The amendment was effected as a sequel to a resolution on the subject passed by All India Congress Committee endorsing the recommendation of the Swaran Singh Committee. It is true that there is no legal sanction provided for violation or non-performance of fundamental duties. There is neither specific provision for enforceability nor any specific prohibition. However, fundamental duties have an inherent element of compulsion regarding compliance. It is said that by their nature, it is not practicable to enforce the fundamental duties, but they can be enforced by suitable legislation and departmental rules of conduct. Appropriate sanctions can be provided for lapse in respect of each fundamental duties, and it is quite practicable to enforce the sanction against every citizen holding a public office. For instance, departmental promotions can be deferred, increments can be withheld, etc. If an officer takes part in a strike or stalls the proceedings of the institution, he can be made to forego the salary for that day. Likewise, sanctions can be provided for professional bodies such as the Bar Council of India, the Medical Council of India, the Institute of Chartered Accountants, and the Institute of Engineers, etc. It is no longer correct to say that fundamental duties enshrined in Article 51A are not enforceable to ensure their implementation and are a mere reminder. Fundamental duties have the element of compulsion regarding compliance. What is needed is to enact a suitable legislation wherever necessary to require obedience of the duties by the citizens with legal sanctions. There is need for comprehensive legislation in this area to ensure a faithful and effective implementation of the fundamental duties. Friends, a number of judicial decisions are present that provide for the enforcement of definite clauses under Article 51A. Comprehensive legislation is required for clauses A, C, E, G, and I. There are many judicial pronouncements regarding the enforceability of fundamental duties. Let us discuss some of these cases. In Chandra Bhavan Boarding and Lodging, Bangalore versus State of Mysore in 1969, the court held that it is a fallacy to think that under our constitution there are only rights and no duties. While rights conferred under Part 3 are fundamental, the directives given under Part 4 are fundamental in the governance in the country. We see no conflict between the provisions contained in Part 3 and Part 4. They are complementary and supplementary to each other. The provisions of Part 4 enable the legislatures and the government to impose various duties on the citizens. The provisions therein are deliberately made elastic because the duties to be imposed on the citizens depend on the extent to which the directive principles are implemented. The mandate of the Constitution is to build a welfare society in which justice, social, economic and political shall inform all institutions of our national life. The hopes and aspirations aroused by the Constitution will be belied if the minimum needs of the lowest of our citizens are not met. Similarly, officers in all India services, administrative, forest and police were not taking the training seriously, resulting in deterioration of these services. Service rules were amended to give weightage to the training and penalize the failure. On a challenge being laid to the constitutionality of the amendment in the rules, in Mohan Kumar Singhania and others versus Union of India, the court ordered to uphold the validity of the amendment. Justice Ratnavel Pandian drew strength from Article 51A. Referring to Clause J, which commands every citizen of India to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement, and it was held that the effort taken by the government in giving utmost importance to the training program of the selectors, so that this higher civil service, being the topmost service of the country, is not wasted and does not become a fruitless endeavor. So, the training period is in consonance with the provisions of Article 51A J. The constitutionality of the amendment was thus upheld. In several cases, the Supreme Court has upheld the validity of laws relating to ecology and environment and has made directions binding the citizens and the state, finding the source of power to do so in Article 51A. In Rural Litigation and Entitlement Kendra versus State of UP in 1986, Justice Ranganath Mishra held that the preservation of the environment and keeping the ecological balance unaffected is task which not only governments but also every citizen must undertake. It is a social obligation, and hence every citizen should be reminded that it is his duty as enshrined in Article 51AG of the Constitution. In Sachidanand Pandey and another versus State of West Bengal in 1987, the court expressed in unmistakable terms that whenever a problem of ecology is brought before the court is bound to bear in mind Article 48A of the Constitution and Article 51AG, which proclaims the fundamental duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers and wildlife, and to have a compassion for living creatures. Policy decisions taken by a state are not ordinarily to be inferred by the courts. But if it is the question of giving effect to the directive principles and fundamental duties, the court is not to shrug its shoulders and say that priorities are a matter of policy not to be touched by the court. The court may always give necessary directions to secure the implementation of directive principles and fundamental duties. In another case, State of Punjab and another versus G.S. Gill in 1997, kindling the spirit of clauses E and J of Article 51A and directive principles contained in Article 38(1), the court reminded the administrators of the government that they too are primarily the citizens, and therefore their vision should be of national interest. The primary responsibility of an administrator is to perform his functions in the services of the nation as an enlightened citizen to strengthen a new democratic state. The public administrator should get rid of all mental reservations on narrow considerations of caste, religion, or region. He should have a wider concern for society. Otherwise, he would not be worthy to be an administrator. In short, the court held that the fundamental duties oblige the administrators of the government to be good administrators. In the state of UP versus Yamuna Shankar Mishra and another case, in 1997, the object of writing the confidential reports and making entries in the character roles were read in the light of Article 51A(j) as giving an opportunity to a public servant to improve excellence. The net of the fundamental duties was spread so wide by the court to spell out the eternal values of honesty, integrity, good conduct, and efficiency getting improved in the performance of public duties, and standard of excellence in services constantly rising to the higher level to be a successful tool to manage these services. These services are to be managed through integrity, honesty, efficiency, and devotion. In the case of Vishakha and others versus State of Rajasthan, the court found it necessary and expedient for employers in workplaces as well as other responsible persons or institutions to observe certain guidelines to ensure the prevention of sexual harassment of women, and set a classical example of its lawmaking power under Article 141 of the Constitution. And these guidelines were the most effective measures for the enforcement of the fundamental duties. To renounce practices derogatory to the dignity of women, a fundamental duty enshrined in Clause E of Article 51A in the effectuation of that duty. Friends, to conclude, we must understand that there is no provision in the Constitution for direct enforcement of fundamental duties. There is no sanction to prevent their violation. These duties, along with the exceptions of fundamental rights, limit the operation of fundamental rights, even though they are not justiciable. Their inclusion has been justified on the basis that they would help to strengthen our democracy. However, an awareness of and adherence to these duties can hardly be brought about by writing down in the Constitution. It is only through education and enlightened public opinion that a feeling of pride and responsibility towards these constitutional duties to the nation can be inculcated in the citizens. With this, we come to an end of this unit. Friends, I thank you all for your patience.